Hello, welcome to the show. My name is Jacob Davidson, and I'm a legal layman from North Texas, and it's a show where I try to learn the law and educate while I'm learning. I am 7 minutes late. And unclean. I feel bad. However, we have got a little document to read, so I'm going to read that. I think for today, after I finish the video and after I make food, I got another video in mind. Or after the stream, I got a video in mind that I want to make. Probably right after this, everything that's been made. So we'll see how that goes. And today's topic will be the Texas Constitution. I was going to read the Federalist paper, but as it says in the description, I realized, maybe the Texas Constitution is probably more appropriate and timely and topical, so I decided to do that instead. Let's see. Is everything... Am I good on YouTube? Am I good on... Yeah, looks like it. I'll retweet my thing. So I got this incense thing. Incense burner right here. Oh. Well, just got ashes all over my pants. I asked myself a question. That was pretty bad, but don't worry about it. What the fuck is Melanie Mac doing? Alright, so. Time to pull up the document. Alright. And here we go. Oh, fuck. I'm used to having to double click on the scene itself. It's 297 pages. Federalist paper was like, what? Also a couple hundred? $300, $400, something like that. So real quick, just gonna do this. Wall with holes. Cardboard. Huh. Alright. Think I figured it out. For this thing. The Texas Constitution Preamble. Humbly invoking the blessing of Almighty God, the people of the state of Texas do ordain and establish this Constitution. And the great thing I think about the states' constitutions is that they inevitably end up having their own Bill of Rights integrated into the constitutions. So it's not like if you read the Texas Constitution and you focus solely on it, you don't have first, second, third, fourth amendments. It's section 1 of Article 1 or section 2, Article 1. The Bill of Rights. That the general, great, and essential principles of liberty and free government may be recognized and established, we declare Section 1, a freedom and sovereignty of state. Texas is a free and independent state, subject only to the Constitution of the United States and the maintenance of our free institution, and the perpetuity of the Union depend upon the preservation of the rights of local self-government, unimpaired to all the states. 1876. Inherent political power and republican form of government. All political power is inherent in the people, and all free government are founded on their authority and instituted for their benefit. The faith of the people of Texas stands pledged to the preservation of the republican form of government, and subject to this limitation only, they have at all times the inalienable right to alter, reform, abolish their government in such manner as they may think expedient. All free men, equal rights. All free men, when they form a social compact, have equal rights, and no man or set of men is entitled to exclusive separate public emoluments or privileges, but in consideration of public service. The cross here is to indicate that the language of this provision is identical to the language of the official legislative measure that originally proposed the provision. A digital image of the original text of the official enrolled measures can be found here. Pardon me just a moment. I won't be like gone. I just need to. There we go. That'll fix that problem. Fix it right up. Equality under the law. Equality under the law shall not be denied or abridged because of sex, color, creed, or national origin. This amendment is self-operative. This is in 1972. Section 4, religious test. No religious test shall ever be required as a qualification to any office or public trust in this state, nor shall any one be excluded from holding office on account of his religion, his religious sentiments, provided he acknowledge the existence of a supreme being. Section 5. Witnesses not disqualified by religious beliefs, oaths, and affirmations. No person shall be disqualified to give evidence in any of the courts of the state on account of his religious opinions, for the want of any religious beliefs, but all oaths or affirmations shall be administered in the mode most binding upon the conscience, and shall be taken subject to the pains and penalties of perjury. Section 6, freedom of worship. All men have a natural and indefeasible. Indefeasible. That's a weird way of turning that word. Indefeasible. Not to be lost, annulled, or overturned. All men have a natural and indefeasible right to worship Almighty God according to the dictates of their own conscience. No man shall be compelled to attend, erect, or support any place of worship, or to maintain any ministry against his consent. No human authority ought, in any case whatever, to control or interfere with the rights of a conscience in matters of religion, and no preference shall ever be given by law to any religious society or mode of worship, but it shall be the duty of the legislature to pass such laws as may be necessary to protect equally every religious denomination in the peaceable enjoyment of its own mode of public worship. This is a 6A. Religious service protections. This state or a political subdivision of the state may not enact, adopt, or issue a statute, order, proclamation, decision, or rule that prohibits or limits religious services, including religious services conducted in churches, congregations, and places of worship in the state by religious organization established to support and serve the propagation of a sincerely held religious belief. That was a 2021 amendment. Appropriations for sectarian purposes. No money shall be appropriated or drawn from the treasury for the benefit of any sect or religious society, theological or religious seminary, nor shall property belonging to the state be appropriated for any such purpose. Section 8, freedom of speech and press libel. Every person shall be at liberty to speak, write, or publish his opinion on any subject, being responsible for the abuse of that privilege. And no law shall ever be passed curtailing the liberty of speech or of the press, in prosecution for the publication of papers investigating the conduct of officers or men in public capacity, or when the matter published is proper for public information. The truth thereof may be given in evidence. And in all indictments or for libels, the jury shall have the right to determine the law and facts under the direction of the courts, as in other cases. Searches and seizures. The people shall be secure in their persons, houses, papers, and possessions from all unreasonable searches or seizures. And no warrant to search any place or to seize any person or thing shall issue without describing them as near as may be, nor without probable cause supported by oath or affirmation. Rights of accused in prosecution. Criminal prosecution. In all criminal prosecution, the accused shall have a speedy public trial by an impartial jury. He shall have the right to demand the nature and cause of the accusations against him, and to have a copy thereof. He shall not be compelled to give evidence against himself, and shall have the right of being heard by himself or counsel, or both, shall be confronted by the witnesses against him, and shall have compulsory process for obtaining witnesses in his favor, except that when the witnesses reside out of the state and the offenses charged is a violation of any of the antitrust laws of the state, the defendant and the state shall have the right to produce and have the evidence admitted by deposition under such rules and laws as the legislature may hereafter provide, and no person shall be held to answer for a criminal offense, unless on an indictment of a grand jury, except in a case in which punishment is by fine or imprisonment. Otherwise, then the penitentiary, in case of impeachment, in cases arising in an army or navy, or in the militia when in actual services in time of war or public danger. Oh wow. Huh. A constitution which makes a distinction between army and navy, and then the militia. There's a word here that I want to look up. Where is it? Penitentiary. Penance. Person convicted of a serious crime. Cool. Bail. All prisoners shall be bailable by sufficient sureties, unless for capital offenses, when the proof is evident, but this provision shall not be construed as to prevent bail after indictment found upon examination of the evidence in such manner as may be prescribed by law. Denial of bail after multiple felonies. A person accused of felony less than capital in the state who has been theretofore twice convicted of a felony, the second convicted being subsequent to the first, both in point of time of commission of the offense convicted therefore. 2. Accused of felony less than capital in the state, committed while on bail for a prior felony for which he has been indicted. 3. Accused of a felony less than capital in the state involving the use of a deadly weapon after being convicted of a prior felony. Or 4. Accused of a violent or sexual offense committed while under the supervision of a criminal justice agency of the state or a political subdivision of the state for a prior felony, after a hearing and upon the evidence substantially showing the guilt of the accused of the offense, and 1 or 3 above of the offense committed while on bail, in 2 above or of the offense, in 4 above committed while under the supervision of the criminal justice agency of the state or political subdivision of the state for a prior felony, may be denied bail pending trial by a district judge in the state if said order denying bail pending trial is issued within 7 calendar days subsequent to the time of the incarceration of the accused, provided however that if the accused is not accorded a trial upon the acquisition of under 1 or 3 above, the accusation and indictments used under 2 above, or the accusation or indictment used under 4, section 4 above, within 60 days from the time of this incarceration. Upon the accusation, the order denying bail shall be automatically set aside unless a continuance is obtained upon the motion or request of the accused, provided further that the right of appeal to the Court of Criminal Appeals of the state is expressly accorded the accused for a review of any judgment or order made hereunder, and said appeal shall be given preference by the Court of Criminal Appeals. In this section, that was A, this is B. In this section, violent offenses means A, murder, aggravated assault if the accused used or exhibited a deadly weapon during the commission of the assault, aggravated kidnapping or aggravated robbery. Sexual offenses means aggravated sexual assault, or indecency with a child. Sexual offenses, indecency with a child would be considered discriminatory to LGBT community in Florida. Denial of bail for a violation of condition of release. Any person who is accused in this state of a felony or an offense involving family violence who is released on bail pending trial and whose bail is subsequently revoked or forfeited for violation of a condition of release may be denied bail pending trial if a judge or magistrate in the state determines by preponderance of the evidence at a subsequent hearing that the person violated a condition of release related to the safety of the victim of the alleged offense or to the safety of the community. I'm kind of excited to burn more frankincense, not gonna lie. Good God, it's 90 degrees. Oh, feel it. Ah, there's slight coloration differences. The forbidden pocky stick. Really? Denial of bail for violation is a 2005 and 2007 amendment, or added and amended. November 1956. So added in 1956, amended in 1977, and added A and B added November 1993. 11C, which was added in 2007, denial of bail for violation of protective order involving family violence. The legislature by general law may provide that any person who violates an order or for emergency protection issued by a judge or magistrate after an arrest for an offense involving family violence, or who violates an active protection order rendered by a court and in a family violence case, including a temporary ex parte order that has been served on the person, or who engages in conduct that constitutes an offense involving the violation of an order described by this section, may be taken into custody and pending trial or other court proceedings denied release on bail if, following a hearing, a judge or magistrate in the state determines by preponderance of the evidence that the person violated the order or engaged in the conduct constituting the offense. Section 12. Habeas corpus. The writ of habeas corpus is a writ of right and shall never be suspended. The legislature shall enact laws to render the remedy speedy and effectual. 1876. Section 13. Excessive bail or fines, cruel or unusual punishments, open courts, remedy by due course of law. Excessive bail shall not be required, nor excessive fines imposed, nor criminal or unusual punishments inflicted. All courts shall be open, and every person or for an injury done him in his land, goods, persons, or reputation shall have a remedy done by course of law. Where was this provision for Vic Mignogna? Double jeopardy is section 14. No person for the same offense shall be put in jeopardy of life or liberty, nor shall a person be again put upon trial for the same offense after a verdict of not guilty in a court of competent jurisdiction. Hold on. I saw something interesting. All right. So apparently, I know I stopped my flow here, but apparently, Project Veritas is suing James O'Keefe. Which is weird. For bullying? That's interesting. Project Veritas suing its former founder, they claim they never fired James O'Keefe and that he's in violation of his employment agreement by starting a new company. That is despite the fact that Project Veritas stopped paying them. Uh, Gaza's representing? Mark. Alright, I'm done with that, bitch. Fucking hell. God, it annoys me so badly. Oh, so that's not right. Even if Randazza was representing. No? Yeah. Uh. Alright. Did I read this already? After a jury verdict? Okay, yeah. The right of trial by jury. The right of trial by jury shall remain inviolate. The legislature shall pass such laws as may be needed to regulate the same and maintain its purity and efficiency, provided that the legislator may provide for a temporary commitment for observation or treatment of mentally ill persons not charged with a criminal offense for a period of time not to exceed 90 days by order of the court without the necessity of trial by jury. I've seen the stupid fucking take. Repentant. If left the Renzo took private inheritance, the client, he'll pass back for getting client with presumably deep pockets, setting milk. Alright. Commitment of persons of unsound mind. No person shall be committed as a person of unsound mind except on competent medical or psychiatric testimony. The legislature may enact all laws necessary to provide for the trial, adjudication of insanity and commitment of persons of unsound mind, and to provide for a method of appeal for judgments rendered in such cases. Such laws may provide for a waiver of trial by jury in cases where the person under inquiry has not been charged with the commission of a criminal offense, be the concurrence of the person under the inquiry or his next of kin, and an attorney ad litem appointed by a judge of either the county or probate court of the county where the trial is being held, and shall provide for a method of service of notice of such trial upon the person under inquiry and his right to demand a trial by jury. saw the strangest thing. Bill of Attainder, ex post facto or retroactive law, impairing obligation of contracts. No bill of attainder, ex post facto law, retroactive law, or any law impairing the obligation of contracts shall be made. There we go. Taking property for public use, special privileges and immunities, control of privileges and franchises. No person's property shall be taken, damaged, or destroyed for or applied to public use without adequate compensation being made, unless by the consent of such person, and only if the taking, damages, or destruction is for the ownership, use, and enjoyment of the property, notwithstanding the incidental use by the state political subdivision, political subdivision of the state, or the public at large, or an entity granted the power of eminent domain under law, or the elimination of urban blight on particular parcel of property. In this section, public use does not include the taking of property under Section A. This section for transfer to a private entity for the primary purposes of economic development or enhancement of tax revenues. On or after January 1st, 2010, the legislator may enact a general or local or special law granting the power of eminent domain to an entity only on 2/3 of votes of members elected to each house. When a person's property is taken under subsection A of the section, except for the use of the state, compensation as described by subsection A shall be first made or secured by a deposit of money, and no irrevocable or uncontrollable grant of special privileges or immunities shall be made but all privileges and franchises granted by the legislature or created under its authority shall be subject to the control thereof. Huh. Imprisonment for debt. No person shall ever be imprisoned for a debt. Deprivation of life, liberty, property, etc. by due course of law. No citizen of the state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disenfranchised except by the due course of law of the land. Outlawry or transportation out of the state for offense. No citizen shall be outlawed, and no person shall be transported out of the state for any offense committed within the same. This section does not prohibit an agreement with another state provided for the confinement of inmates of the state in the penal or correctional facilities of the state. Corruption of blood, forfeiture of estate, suicides, and suicides. No conviction shall work corruption of blood or forfeiture of estate, and the estates of those who destroy their own lives shall descend or vest as in case of natural death. The right to keep and bear arms. Every citizen shall have the right to keep and bear arms in lawful defense of himself or the state. but the legislator shall have power by law to regulate the wearing of arms with a view to prevent crime. What does that even mean, though? Alright, time to burn some frankincense this time. I kind of feel bad for Nick because every time he goes on a vacation, something fucking happens. Alright. There we go, it sounds proper now. Military subordinate to civil authority. The military shall at all times be subordinate to the civil authority. Quartering soldiers in houses. No soldier shall in time of peace be quartered in the house of any citizen without the consent of the owner, nor in time of war, but in a manner prescribed by law. Perpetuities and monopolies, primogeniture or entailments. Perpetuities and monopolies are contrary to the genius of free government, and shall never be allowed, nor shall the law of... Oh, fuck. Primogenitor. The state of being the firstborn. The right of succession belonging to the firstborn, especially by feudal... Okay. Nor shall the law of primogeniture or entailments ever be enforced in the state. Right of assembly, petition for redress of grievances. The state shall have the right in peaceable manner to assemble together for their common good and apply to those invested with the powers of government for redress of grievance or other purposes by petition, address, or remonstrance. Suspension of laws. No power of suspending laws in this state shall be exercised except by the legislature. Bill of Rights except from powers of government and inviolate. To guard against the transgression of this of the high powers herein delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of the government and shall ever remain inviolate. And all laws contrary thereto or the following provisions shall be void. Rights of the crime victims. The crime victim has the following rights. The right to be treated with fairness and respect for the victim's dignity and privacy throughout the criminal justice process, and the right to be reasonably protected from the accused throughout the criminal justice process. B. On request of crime victim, the crime victim has the following rights. The rights to be notification of court proceedings, the right to be present in all public court proceedings related to the offense, unless the victim is to testify and the court determines that the victim's testimony would be materially affected if the victim hears other testimony at the trial. The right to confer with a representative of the prosecutor's office. The right to restitution and the right to inform about the conviction sentence, imprisonment, and release of the accused. The legislature may enact laws to define the term victim and to enforce these and other rights of crime victims. The state throughout its prosecuting attorney has the right to enforce the rights of crime victims. The legislature may enact laws to provide that a judge, attorney for the state, peaceable officer, law enforcement agency is not liable for a failure or inability to provide the right enumerated in the section. The failure or inability of any person to provide a right to service or enumerated in this section may not be used by a defendant in a criminal case as a ground for appeals or post-conviction writ of habeas corpus. A victim of, or guardian or legal representative of a victim has a standing to enforce the rights enumerated in this section but does not have standing to participate as a party in a criminal proceedings or to contest the disposition of any charge. This confuses me, I think. Okay. Funds for compensations to victims of crime. The compensation to victims of crime fund created by general law and the compensation to victims of crime auxiliary fund created by general law are each a separate dedicated account in general revenue fund. Except as provided by subsection C of this section and subject to legislative appropriation, money deposited to the credit of the compensation to the victims of crimes fund or compensation to victims of crime auxiliary fund from any source may be expended as provided by law only for delivering or funding victim-related compensation services or assistance. The legislature may provide by law that money in the compensation of victims of crime fund or in compensation to victims of crime auxiliary fund may be expended for the purpose of assisting victims of episodes of mass violence if other money appropriated for emergency assistance is depleted. Marriage in the state shall consist only of a union of one man and one woman. The state or political subdivision of the state may not create or recognize any legal status identical or similar to marriage. But why? That's weird. Added 2005. Public access and use of public beaches. In this section, a public beach means a state-owned beach bordering on the seaward shore and of the Gulf of Mexico, extending from mean low tide to the landward boundary of the state-owned submerged land in any larger area, extending from the line of mean low tide and the line of vegetation bordering the Gulf of Mexico, to which the public has acquired right of use of easement to or over the area by prescription or dedication, or has established and retained the right by virtue of continuous right in the public under Texas common law. The public individually collectively has an unrestricted right to use or right of ingress and to right of ingress to and ingress from a public beach. The right granted by this subsection is dedicated as a permanent easement in favor of the public. The legislature may enact laws to protect the right of the public to access and use public beach to protect the public beach easement from interference and encroachment. Whoops. This section does not create a private right of enforcement. God, how many sections? Okay. The right to hunt, fish, and harvest wildlife. The people have the right to hunt, fish, and harvest wildlife, including by the use of traditional methods, subject to laws or regulations to conserve and manage wildlife, preserve the future of hunting and fishing. Hunting and fishing are preferred methods of managing and controlling wildlife. This section does not create any provision of law relating to trespass, property rights, or eminent domain. The section does not affect the power of the legislature to authorize the municipality to regulate the discharge of a weapon in the populated area in the interest of public safety. The right of certain facility residents to designate essential caregiver. The resident of nursing facilities, assisted living facilities, intermediate care facilities, or for individuals with the intellectual disability, residents providing home and community-based services, or state-supported living centers, as those terms are defined by general law, has the right to designate an essential caregiver with whom the facility, residence, or center may not prohibit in-person visitation. Notwithstanding subsection A of this section, the legislature by general law may provide guidelines for facility resident or center described by subsection A of this section to follow in establishing essential caregivers, visitation policies, and procedures. Give me just a moment. Oh. That was rough. The Bill of Rights is 14 pages in the Texas Constitution. Article 2 is only one, like less than one. Separation of powers of government among 3 departments. The power of governments of the state of Texas shall be divided into 3 distinct departments, each of which shall be confided to a separate body of magistracy, to wit, those which are legislative to one, those which are executive to another, and those which are judicial to another. And no person or collection of persons being of one of these departments shall exercise any power properly attached to either of the others, except in instances herein expressly permitted. Article 3, the legislative department, is sizable. That is a lot. Okay. I'll probably not be able to go through this all today. Not even the legislative branch portion. There's a stop at section 50. No, it doesn't. This will be a multi-day endeavor. Unlike the U.S. Constitution. 67 sections within the legislative branch. Senate and House of Representatives. The legislative power of the state shall be vested in the Senate and the House of Representatives, which shall together be styled the legislature of the state of Texas. Membership of Senate and House of Representatives. The Senate shall consist of 31 members. The House of Representatives shall consist of 150 members. 150 members, yeah. Election and term of office of senators. The senators shall be chosen by the qualified voters for the term of 4 years, but a new senate shall be chosen after every apportionment, and a senator elected after each apportionment shall be divided by lot into 2 classes. The seats of the senator of the first class shall be vacated at the expiration of the first 2 years, and those of the second class at the expiration of 4 years, so that 1/2 of the senators shall be chosen biennially thereafter. Senators shall take office following their election on the day set by law for the convening of regular session of the legislature, and shall serve thereafter for the full term of years to which elected. Election of and term of members of House of Representatives. The member of the House of Representatives shall be chosen by qualified voters for the term of 2 years. Representatives shall take office following their election on the day set by law for convening the regular session of the legislature, and shall serve thereafter for the full term to which elected. Meetings, order of business. The legislature shall meet every 2 years at such time as may be provided by law, and at other times when convened by the governor. This is being practiced this session. We have an emergency session called by the governor. When convened in regular session, the first 30 days thereof shall be devoted to the introduction of bills and resolutions acting upon emergency appropriations, passing upon the confirmations of the recess appointees of the governor, and such emergency matters as may be submitted by the governor, and special messages to the legislatures. During the succeeding 30 days of the regular session of the legislature, the various committees of each house shall hold hearings to consider all bills and resolutions and other matters then pending, and such emergency matters as may be submitted by the governor. During the remainder of the session, the legislature shall act upon such bills and resolutions as may be then pending, and upon such emergency matters as may be submitted by governor, and special messages to the legislature. See, notwithstanding subsection B, either the House may determine its order of business by an affirmative vote of 4/5 of its membership. And give me just a moment. I have something I need to look at. Alright, I have so many fucking idiots. I'm gonna distract us for a moment after the ad read because I think broke mobile chat. Oh no, don't break mobile chat. Don't do that. No good. I like mobile chat. Oh wow, it works now. Oh. Well, it works. You didn't break it. Good job, NC Native. The Dragon's Treasure is a haven for anime and tea lovers. If you want some fantastic tasting tea, I implore you to go to the Dragon's Treasure and use code Layman at checkout for 10% off your purchase. That 10% off will get you just about everything on the site. The Mana Potion, the Sebastian's Morning Old Grey, the Red Chocolate Cake, even the membership. You can get 10% off the membership. Usually you have to get a membership to get some percent off. The Ingenuity Strainer is a really good product. I used it before I got the larger production kettle that I have that allows me to brew basically like five times the amount of tea in one sitting. It's fantastic. I love it. They now do coffee, and in fact, your coffee can come with separate. If I remember right, he made it so that you could select the roast on it as well. Either that or you can ask him how to do the roast. But that is the Dragon's Treasure, and remember to use code Layman at checkout for 10% off. Now, I'm going to get this set up so I can hear it. I'm going to... I assume this is a slapdown on Trudeau in the middle of this Texas Constitution talk. Which is, I know, a little weird, but please please indulge me a little bit. Unmute. Do that. Here we go.
Yes, Mr. Speaker, I was a high school teacher before getting into politics, and I'm having a little trouble remembering what exactly the job that the Leader of the Opposition had before getting into politics.
Yes, and he left right in the middle of the semester, and I'm having trouble remembering why. Oh! Now, Mr. Speaker. He certainly was not a math teacher. His own finance minister says the deficits pour fuel on the inflationary fire, right before she introduced $60 billion more deficit spending measures. How much will that add to the inflation rate Canadians have to pay? How much?
Hear, hear. The Right Honourable Prime Minister.
Yes, Mr. Speaker, I was a high school teacher before getting into politics, and I'm having a little trouble remembering what exactly the job that the Leader of the Opposition had before getting into politics.
God, what a fucking dick. I hate him so much. I've never met a more useless individual. Actually, I may have met a more useless individual, but I've God, Trudeau. He only wins because he's pretty. I think he knows that. Tea break? Yep. Qualifications of senators. No person shall be a senator unless he be a citizen of the United States and at the time of his election, qualified voter of the state, and shall have been a resident of the state 5 years next preceding his election, and the last year thereof a resident of the district for which he shall be chosen, and shall have attained the age of 26 years. I'm 2 away from senatorship in Texas. Qualifications of representatives. No person shall be a representative unless he be a citizen of the United States and at the time of election be a qualified voter of the state, and shall have been a resident of the state 2 years next preceding his election, the last year thereof a resident of the district for which he shall be chosen, and shall have attained the age of 21 years. I have been qualified for this position for 3 years. It almost makes me want to run. I almost want to. I have 2 options. I have 2 options here. If I want to, I could run for U.S. House Representative next year, make my run for it at the start of the year, basically when I turn 25, or run for Texas Senator or Texas Representative whenever I want. Each House judge of qualifications and elections of its members, elections contest. Each House shall be the judge of the qualification and election of its own members, but contested elections shall be determined in such a manner as shall be provided by law. President pro tempore of Senate, Lieutenant Governor, vacancy, Speaker of House Representative, and other officers. The Senate shall at the time, the beginning and close of each session, and at such other times as may be necessary, elect one of its members president pro tempore, who shall perform the duties of the lieutenant governor in any case of absence or temporary disability of that officer. If the office of lieutenant governor becomes vacant, the president pro tempore of the Senate shall convene with the committee of the whole Senate within 30 days after the vacancy occurs. The committee of the whole shall elect one of its members to perform the duties of the lieutenant governor in addition to the member's duties as senator until the next general election. If the senator so elected ceases to be a senator before the election of a new lieutenant governor, another senator shall be elected in the same manner to perform the duties of the lieutenant governor until the next general election, until the committee of the whole elects one of its members for this purpose. The president pro tempore shall perform the duties of lieutenant governor as provided by the subsection. House of Representatives shall, when it first assembles, organize temporarily and thereupon proceed to elect the election of speaker from its own members. Each house shall choose its other officers. Quorum adjournment from day to day. Compelling attendance. 2/3 of each house shall constitute a quorum to do business, but a smaller number may adjourn from day to day to compel the attendance of absent members in such a manner and under such penalties that each house may provide. Rules of procedure, punishment, or expulsions of members. Each house may determine the rules of its own proceedings, punishment, and punish members for disorderly conduct, and with the consent of 2/3 expel a member, but not a second time for the same offense. Journals of proceedings, record votes. Each house of the legislature shall keep a journal of its proceedings and publish the same. A vote taken by either house may be by record vote with the vote of each member entered in the journal of that house. If the vote is the final passage of a bill, the resolution proposing or ratifying a constitutional amendment, or another resolution other than a resolution of purely ceremonial or honorary nature, either house by rule may provide for exception to this requirement for the bill that applies only to one district or political subdivision of the state. For purposes of the subsection, a vote on final passage includes a vote on third reading in a house, or second reading if the house suspends the requirements for three readings, on whether to concur in the house amendments, and on whether to adopt the conference committee report. The yeas and nays of the members of either house of any other question shall, at the desire of any three members present, be entered on the journal. Each house shall make each record vote required under subsection B of the section, including the vote of each individual member as recorded in the journal of that house, available to the public for a reasonable period of not less than 2 years through the internet or successor electronic communication system accessible by the public for a record vote on bill or on resolution proposing or ratifying the constitutional amendment. The record vote must be accessible to the public by reference to the designated number of bills or resolution by reference to its subject. Just a moment, I need a drink. Yeah. Oh. How fantastic. Forgot to change the scene. Oh well. It's almost done. When vacancies occur in either the House, the governor, or the person exercising the power of the governor shall issue writs of election to fill such vacancies. And should the governor fail to issue a writ of election to fill any such vacancies, within 20 days after it occurs, the returning officer of the district in which such vacancy may have happened shall be authorized to order an election for that purpose. That actually begs the question. Bryan's Latin District. Texas House District 2 map. Texas State House District 2. Guess I'll just look here. Oh god, it's crashing. God damn it. God damn it. Give it a minute. It'll return. Sorry, it's still loading. Or crashing. I guess I should close the browser and reopen it. Come on. Crash, browser. Uh-oh. Everything's going. Oh god, finally. That's not what I wanted. I wonder if Andrew J. Hamilton was awake. I bet he was. Oh, you've got to be shitting me. Another. It's great. It's lovely. But I have choppy connection. Where am I? Where am I at now? It's not your connection. It's my fucking internet. The opposition clique and faction of Southern Party who opposed the session and reopening. Johnson was elected to the House of Representatives as an independent Democrat representing the Western District. Ah. What the hell? That's so fucking weird. Alright. So he would oppose slave trade and secession. But then after his governorship in Texas, after we were forcibly reunioned, he would withdraw his support of black suffrage. Alright then. Hamilton be fucking wilding. Weirdo. Andrew Jackson Hamilton. The legislature may provide by general law for filling a vacancy in the legislature without an election if only one person qualifies and declares a candidacy in an election to fill the vacancy. Sorry, I'm messing with my ashes. Privilege from arrest during legislative sessions. Senators and representatives shall, except in cases of treason, felony, or breach of the peace, be privileged from arrest during the session of the legislature and in going to and returning from the same. Disrespectful or disorderly conduct, obstruction of proceedings. Each house may punish by imprisonment during its session any person not a member for disrespectful or disorderly conduct in its presence, or for obstructing any of its proceedings, provided such imprisonment shall not at any time exceed 48 hours. Open sessions. The sessions of each house shall be open except the Senate when in executive session. Adjournment. Neither house shall, without the consent of the other, adjourn for more than 3 days, nor to any other place where the legislature may be sitting. Ineligibility for other offices, voting for other members, interest in state or county contracts. No senator or representative shall, during the term of which he was elected, be eligible to 1. Any civil office of profit under the state which shall have been created, or the emoluments of which may have been increased during such terms, or 2. Any office or place the appointment to which may be made in whole or in part by either branch of the legislature, provided, however, the fact that the term of the office of senator and representatives does not end precisely on the last day of December, but extends a few days into January of the succeeding year, shall be considered as de minimis, and the de minimis unfathomable. Too trivial or minor to merit consideration, especially by law. And the succeeding and the ineligibility herein created shall terminate on the last day in December of the last full calendar year of the term of which he was elected. No member of the House shall vote for any other member for an office whatever which may be filled by vote of the legislature, except in such cases as are in this Constitution provided, nor shall any member of the legislature be interested either directly or indirectly in any contract with the state or any county thereof authorized by any law passed during the term of which he was elected. Eligibility of collectors of taxes or persons in trust. Ineligibility persons holding other offices. No judge of any court, secretary of state, attorney general, clerk of any court of record, or any person holding a lucrative office under the United States or this state, or any foreign government shall, during the term of which he is elected or appointed, to be eligible to legislature. Eligibility of collectors of taxes or persons entrusted with the public money. No person who at any time may have been a collector of taxes or may have been otherwise entrusted with public money shall be eligible to the legislature or to any office of profit or trust under the state government until he shall have obtained a discharge for the amount of such collections or for all public monies with which he may have been entrusted. Words spoken in debate. No member shall be questioned in any other place for words spoken in a debate in either house. It's a weird provision, but I guess it makes sense. You wouldn't want to have someone impugn you for what you said during, I don't know, putting up a fight for a law or whatever. Disclosure of personal or private interests in measures or bill not to vote member. A member who has a personal or private interest in any measure or bill proposed or pending before the legislature shall disclose the fact that the house of which he is a member shall not vote thereon. 1, 2, 3, 4. Okay. Vacancy following removal from district or county from which elected. If any senator or representative remove his residence from the district or county for which he was elected, his office shall thereby become vacant, and the vacancy shall be filled as provided in section 13 of this article. I'm going to commit a crime and eat on stream because I feel the hunger. Fascinating. The rice cracker broke in half. Rice cake, rather. Oh, no. Hmm. Section 23A was repealed in 1997. All right, sorry about that. Section 24, compensation and expense of members of legislature during duration of regular session. A member of the legislature shall receive from the public treasury a salary of $600 per month. Hold on. Unless a greater amount is recommended by the Texas Ethics Commission as provided by the voters of the state, in which case the salary is that amount. Each member shall also receive a per diem set by the Texas Ethics Commission for each day during each regular and special session of the legislature. No regular session shall be of longer duration than 140 days. In addition to the per diem, the members of the House shall be entitled to mileage at the same rate as prescribed by law for employees of the state of Texas. per diem means just as needed, I believe. Allowance for lodging, meal, and incidental costs incurred while on official government travel. The Texas Ethics Commission, legislative salaries, and per diem. The Texas Ethics Commission is a state agency consisting of the following 8 members. 2 members of different political parties appointed by the governor from a list of at least 10 names submitted by the members of the House of Representatives from each political party, required by law to hold a primary. 2 members of different political parties appointed by the governor from a list of 10 different names submitted by the members of the Senate from political party required by law to hold a primary. Two members of different political parties appointed by the Speaker of the House of Representatives from a list of at least 10 names submitted by members of the House of which... So it's a lot of the same, but it's who's picking. So the commission is made up of 8 people. 2 picked out by the governor. 2 picked out by... Two picked out by the governor, or 4 in total, from a list of at least 10 names submitted by the House and the Senate. The Speaker shall appoint 2, and the Lieutenant Governor shall appoint 2. The governor may reject all names on any list submitted under Section A1 or 2 of the section require a new list to be submitted. The member of commission shall elect annually the chairman of the commission. With exception of the initial appointments, commission members serve for 4-year terms. Each appointing official will make 1 initial appointment for 2 years and 1 initial appointment for a 4-year term. A vacancy on the commission shall be filled for an unexpired portion of the term in the same manner as the original appointment. A member who has served for 1 term and any party of the second is not eligible for reappointment. The commission has a power and duty provided by law. Commission may recommend salary of the members of the legislature. That the salary of the Speaker of the House of Representatives and the Lieutenant Governor be set at an amount higher than that of the other members. The commission shall set the per diem of members of the legislature and the Lieutenant Governor, and the per diem shall reflect reasonable estimates of cost and may be raised or lowered biennially as necessary to pay these costs. But the per diem may not exceed during a calendar year the amount allowed as of January 1st of that year for the federal income tax purposes, as deductions for living expenses incurred in the legislative day by a state legislature in connection with the legislature's business as a legislature, disregarding any exception in federal law for the legislator residing near the Capitol. At each general election for the state, county officers following a proposed change in salary, the voters shall approve or disapprove the salary recommended by the commission. If the commission recommends a change in salary, if the voters disapprove the salary continues the amount paid immediately before. Disapproval until another amount is recommended by the commission and approved by the voters. If the voters approve the salary and the approved salary takes effect to January 1st of the next odd numbered year. So 13579. The Senate shall be senatorial districts. The state Senate shall be divided into senatorial districts of contiguous territory, and each district shall be entitled to elect one senator. Appointment of members of House of Representatives. The members of the House of Representatives shall be apportioned among the several counties according to the number of population in each, as nearly as may be, on a ratio obtained by dividing the population of the state, as ascertained by the most recent United States census, by the number of members of which the House is commissioned, provided that whenever a single county has sufficient population to be entitled to a representative, such county shall be formed into a separate representative district, and when 2 or more counties are required to make up the ratio of representation, such counties shall be contiguous to each other, and when any one county has more than sufficient population to be entitled to 1 or more representatives, such representative or representatives shall be apportioned to such county. And for any surplus of population, it may be joined in a representative district in which the other contiguous counties or counties, with any other. 26A has been repealed as of 99. I was 11 months old when this happened. Fantastic. Elections for legislature. Election for senator and representatives shall be general throughout the state and shall be regulated by law. Ugh. The time for apportionment by legislative redistricting board. The legislature shall, at its first regular session after the publication of each United States decennial census, apportion the state into senatorial and representative districts. Districts agreeable to the provision of section 25 and 26 of this article, in the event of the legislature shall at any such first regular session follow the publication of a United States decennial census, fail to make the apportionment, same shall be done by the legislative redistricting board of Texas, which is hereby created and shall be composed of 5 members as follows: the Lieutenant Governor, Speaker of the House of Representatives, the Attorney General, the Comptroller of Public Accounts, and the Commissioner of the General Land of Office, a majority of whom shall constitute a quorum. Said board shall assemble in the city of Austin within 90 days after the final adjournment of such regular session. The board shall within 60 days after assembling apportion the state into senatorial and representative districts, or into senatorial or representative districts as the failure of action of such legislature may make necessary. Such apportionment shall be in writing and signed by 3 or more of the members of the board, duly acknowledged as the act and deed of such board, and when so executed and filed with the Secretary of State, shall have force and effect of law. Such apportionment shall become effective at the next succeeding statewide general election. The Supreme Court of Texas shall have jurisdiction to compel such a board to perform its duties in accordance with the provision of this section by writ of mandamus or other extraordinary writs conformable to the usage of law. The legislature shall provide necessary funds for clerical and technical aid and for other expenses incidental to the work of the board, and Lieutenant Governor and the Speaker of the House of Representatives shall be entitled to receive per diem and travel expenses during the board session in the same manner and the amount of as they would attending a special session of the legislature. (29) Enacting clause of laws. Enacting clause of all laws shall be enacted by the legislature of the state of Texas. Laws passed by bill, amendments changing purpose prohibited. No law shall be passed except by bill, and no bill shall be so amended in its passage through either house as to change its original purpose. Originating in either house amendment. Bills may originate in either house, and when passed by such house may be amended, altered, or rejected by the other. Reading on several days. No bill shall have the force of law until it has been read on 3 several days, in each house and free discussion allowed therein, but 4/5 of the house in which the bills may be pending may suspend this rule, the yeas and nays being taken on the question of suspension and entered upon the journal. Origination of revenue bills in House of Representatives. All bills for raising revenues shall originate in the House of Representatives. Okay. Defeated bills and resolutions. After a bill has been considered and defeated by either House of Legislature, no bill containing the same substance shall be passed into law during the same session. After a resolution has been acted on and defeated, no resolution containing the same substance shall be considered at the same session. Subject and titles of bills. No bill except general appropriation bills, which may embrace the various subjects and accounts for and on account of which monies are appropriated, shall contain more than one subject. The rules of procedure of each house shall require that the subject of each bill be expressed in its title in a manner that gives the legislature and public reasonable notice of that subject. The legislature is solely responsible for determining compliance of the rule with the rule. A law including what the fuck? I know. Right, split the shit out. Your bed is fucking whack. A law including a law enacted before the effective date of the subsection may not be held void on the basis of an insufficient title. Subjects and titles of bills. Which may embrace various subjects and accounts, and on account of which monies are appropriated. The rules of procedure of each house shall require that the subject of each bill be expressed in its title in a manner that gives the legislature and the public reasonable notice that the subject of that subject. The legislature is solely responsible. Okay. And no bill shall be held void on the basis of insufficient title. Revival of amendment by reference prohibited, reenactment and publication at length. You know, I might end this early, and like 6 minutes early, because I want to go and get cleaned up, and then I want to cook. And I'm only halfway through just the legislative portion. Revival or amendment by reference prohibited, reenactment and publication at length. No law shall be revived or amended by reference to its title, but in such case the act revived or the section or sections amended shall be reenacted and published at length. Reference to committee and report. No bill shall be considered unless it has been first referred to a committee and reported therein, and no bill shall be passed which has not been presented and referred to and reported from a committee at least 3 days before the final adjournment of the legislature. Signing bills and joint resolutions. Entry on journal. The presiding officer of each house shall, in the presence of the house over which he presides, sign all bills and joint resolutions passed by the legislature after their titles have been publicly read before signing, and the fact of signing shall be entered on the journals. Time of taking effect of laws. No laws shall be passed by the legislature except the General Appropriation Act shall take an effect or go into force until 90 days after the adjournment of the session at which it was enacted, unless the legislature shall, by a vote of 2/3 of all the members elected to each house, otherwise direct said vote to be taken by yeas and nays, entered upon the journal. Special sessions. Special sessions, subjects of legislation during when the legislature shall be convened in the special session, there shall be no legislation upon subject other than those designated in the proclamation of the governor calling such session or prescribed to them by the governor, and no such session shall fall or shall be of longer duration than 30 days. Elections by Senate and House of Representatives. In all elections by the Senate and House of Representatives, jointly or separately, the vote shall be given viva voce, except in the election of their officers. Viva voce is oral rather than written, spoken. Viva voce. Revision of laws. The legislature shall provide for revising, digesting, and publishing the laws civil and criminal, provided that in the adoption of and giving effect to any such digest or revision, the legislature shall not be limited by sections 35 and 36 of this article. In this section, revision includes a revision of the statutes on a particular subject and the enactment having the proposed declared in the enactment of codifying without substantive change statutes that individually relate to different subjects. I think I'll wrap it up here. And my personal counter over there will tell you how many times I repeat something. Or tell me, rather. He won't tell you, because I'll have ended the stream by that point. Today? He's counting ahead. False. Bad. So, we're going to end the stream here. I'm going to do this first. Go to the Dragon's Treasure. Use code Layman. You'll get 10% off the purchase. And for their coffee, not only do you have the option of how much you can get in the coffee, you can now get you can now select the roast level for your coffee. Oh, it loads up after, huh? Yeah, medium, light, or dark roast. You can get 12 ounces or 2 pounds of it. Let me go here. Yeah. Whole bean, grounded, or unroasted. Yep. And the code Layman discount will get you 10% off of everything that you see on the front page. The tea of the month, Sebastian Morning Earl Grey, everything. That includes the Dragon Wings membership and tea wares and merchandise. So I highly recommend, if you go to Dragon's Treasure, and I can't recommend it enough, to use code Layman for 10% off, so you can have fantastic tasting tea with fantastic savings. And to wrap up, after the ad, remember you can find me at Legal Layman on Twitter. Remember to like and subscribe on Rumble and on YouTube. It helps the growth. I've been seeing some really good growth over the past couple days. It makes me very happy to see. And I will work to release a video in maybe a couple days. I just need to get my Vegas Pro to start working so I can start editing. And hopefully I'll get something out for you guys soon, because I have an idea. I have thoughts. Yesterday I realized I have a message to say. All the messages, and I want to give it kind of with the polish. So I'll be covering something outside of a stream that it will be exclusively pre-recorded, so you can watch that there on the Legal Layman channel and on Legal Layman at locals, or at on Rumble. With that, you can find me on Twitter, Legal Layman with 2 N's at the end. I am on locals at legallayman.locals.com, or if you prefer the blockchain cryptocurrency stance, you can go to backto.buy/Legal Layman and support me there. It's a Patreon without censorship, bullshit, and not tied to any banks. Thank you for watching the show. Thank you for the comments. It was fantastic. I got a little bored reading this, I'll admit. I was really interested in the Bill of Rights and the Texas Constitution, and I didn't really think that the legislative stuff of it would have been so dreadfully boring. So I got to deal with that. And I'm going to probably do my Federalist readings on a recorded thing. Thank you for watching. I appreciate everything. I'll see you guys later. I'll see you guys on the replay. I still appreciate views on the replay, even if you don't come. And I appreciate the comments very much. And if Rumble, if you've seen this video, I highly recommend you monetize comments as well as the chats, because if someone would like to pay to make a comment, I think they should. It's a feature on YouTube. Make it real. Hang loose.